So first of all, let me thank Charles and Michelle and Fran for convening the workshop. It's such a critical issue, and I think this is by far the most global gathering in which I've been involved. As many of you know, there's a special session of the World Health Assembly approaching in late November and early December. That was determined in May, right? And the explicit purpose is to determine whether an international pandemic agreement and maybe even a treaty should be formed under the auspices of the World Health Organization. I've been involved in bits and pieces around lots of different parts of the negotiations leading to that special session. I suspect quite a few of you have, and sort of ABS is not an avoidable question. And so, sort of the invitation was sort of just perfectly timed because it gave me the opportunity to really think through how we should think about access and benefit sharing in the context of a pandemic treaty. Now, it's very likely that sort of the special session in November and December is unlikely to result in any immediate action. And so I really framed the chapter in terms of looking forward, right? So even if you don't get a pandemic treaty in the near term, I think it is inevitable that access and benefit sharing questions will pervade international public health agreements in the future. And so with that as the kind of the backdrop and the framing of the chapter, I really sort of try to make three arguments. The first is sort of on the mechanisms within the Nagoya Protocol that are suited to sort of ABS, right? And so I'd sort of spend some time analyzing Article 4.4. I don't think it's very promising, but I do think that any pandemic treaty sort of, and I probably should make an intermediate step here and sort of credit to Michelle and Mark Eccleston Turner, who, I mean, so far as I know, have written the most authoritative piece, albeit short, on sort of the BioHub proposal or the BioHub network that's been sort of consummated by WHO. It is always spoken or frequently spoken in the same breath as international pandemic agreements. They haven't been explicitly tied, but again, they're sort of one of these kinds of mechanisms or agreements that I suspect will proceed whether or not there's a pandemic treaty. And so I analyzed sort of Article 4.4. I don't think it's very promising. I think reaching those kinds of agreements are extraordinarily burdensome and difficult. As far as I know, we really only have two. One of those is pathogen specific, right? So the Pandemic Influenza Preparedness Framework. Similarly, I don't think Article 8 is very promising. The language of Article 8, as many of you know, is really specific to emergencies, not even emergency preparedness, right? So I actually think Nagoya, even though I think that its drafters took sort of care to understand that it was going to affect and influence other multilateral agreements, really provided not a very long menu of options within the text itself. And that to me leaves Article 19, right? So this kind of urging of standard material transfer agreements or standard clauses. And the argument in the chapter is that that is the most promising route for ABS sort of considerations to be effectively joined with a pandemic agreement. The idea that sort of a country like Brazil will contribute pathogen samples to a biohub for a different price and in a different way than a country like, let's say Libya. This biodiverse, rich countries are going to approach those biohubs in different ways, but you can actually tailor standard material transfer agreements, at least to sort of address the issue. Related to argument one is argument two. All of the UN specialized agencies that are charged with some aspect of ABS. So WHO is sort of central to my life just as a scholar, but of course there's the World Intellectual Property Organization, the Organization for Animal Health or OIE, the FAO, UNESCO. Really sort of all of the sort of major specialized agencies have some role to play in the implementation of ABS measures that may be affected by international public health agreements. And so there isn't, I mean, a lot of you know, WHO has coordinated with the CBD sort of Conference of the Parties in the Secretariat since 2012. So it's been about 10 years, but as I mentioned during Michael's talk, there is this tension, right? WHO institutionally thinks that benefit sharing poses a risk to international health research, and they're correct. Right now, we can come up with different conclusions as to who's right and who's wrong in terms of what those benefits should look like, but they are correct that asking for benefits or requiring benefits is something to be addressed. But really, the number of specialized agency coordinating committees is pretty small, right? So the second argument or proposal in the chapter is that there be a standing committee of all of the specialized agencies, or a representative from all of the specialized agencies, and civil society and sort of relevant stakeholders, right? That kind of ABS coordinating committee should meet regularly, and it should consider how to coordinate all of those special agency mandates across international public health agreements, probably with the World Health Organization as the lead. I'm certain that the CBD Secretariat would have a different view. And then finally, this the question of digital sequence information, which there's just some really thoughtful pieces in the workshop, and I almost hesitate to weigh in because it isn't the area where I've written or contributed the most. But I will put some thoughts on what the contribution of the paper is, which is I think the right framing, or at least the framing I use, is information as protected by international human rights law, right? So the right to communicate, the right to speak, the right to share data, right? Which is sort of protected in a different way than benefit sharing as it is envisioned or as it is framed under ABS instruments like CBD and Nagoya. And I don't think there's an easy question there, but what I propose, and I think it's original. I looked pretty hard to make sure that it was, is to essentially create a framework where digital sequence information attributed to genetic resources protected by the major international legal instruments is a form of copyright. So essentially, if a sovereign country can prove attribution from the digital sequence information to the genetic resource that is protected, then they have a right to something like a royalty or a claim on it, or benefits resulting from the information. But similarly, like copyright law, there are exceptions for what we call in US fair use. I actually don't know what it's called in Australia or some of the other countries whose sort of residents and citizens are participating. And so, for example, for public health emergency, that would be the sort of the picture of a fair use of the information that would in fact not require, at least wouldn't require ex ante benefit sharing. Maybe there could be some kind of arrangement ex post. So those are the sort of the three main arguments, or what I hope to be contributions of the chapter. And I really look forward to people's thoughts.
Thank you, Sam. That was excellent. And, in terms of your perspectives, I've just got, actually, if anyone else wants to jump in, but I've got a bit of a question, I guess, around, you talk about, challenges with country of origin in relation to, pandemic viruses. Michelle, Charles and I have played around a bit with just different sort of points in time for, I guess, the starting point and endpoints of traceability, like, country of intermediate host organism, or evolutionary origin, or the country of the human host, or the country of infection, collection, isolation, you name it. There's a stack of different points in time. Do you have any thoughts about, or solutions for establishing those starting points and endpoints for traceability for the purposes of pandemic viruses?
I don't know that I have any. I don't have any kind of like technical suggestions. I think the most important part of the proposal from my perspective is that it is on the burden of the state claiming that benefits should accrue. And so in that sense, I think it opens it up either for international agreement, or it can sort of just function as a matter of domestic legislation and then diplomacy. And I envision that it will be any one of those things or all of them, depending on the circumstances. And I think it probably should be. But I think the most important thing is the country laying the claim that should be burdened with proving it, either as to the party that is to pay, or to remunerate, or to recompense, or is making it sort of like case in front of a tribunal, if such a tribunal is convened, either under an international pandemic treaty, or just any public health agreement in which ABS matters are considered. I realize that's a little bit of a bob and weave. I'm familiar with your really spectacular work, and I'm sad I don't have anything else to add.
Can I jump in with the sort of follow on to your question? So sometimes the origins of these things are very important and very hard to prove. So for example, with the SARS-CoV-2, we still don't have a definitive answer of where it came from. Could it come from like a border region of China, from a country adjoining? We don't really know that. And for Zika, for example, Zika has been circulating from Africa for decades before it came to Brazil. So do those other countries have a right to claim, some benefit from this? It just becomes like very quickly inoperable. And with SARS-CoV-2, so every variant that comes out, should every country where the variant is first discovered put a claim for it? How will that work with new vaccines getting made? It just becomes like, for me, from a practical point of view, it adds a lot of delays to the whole system.
No, that's absolutely right. But I think I try to build that ambiguity and difficulty into emergency circumstances at least, right? So if you cannot definitively prove satisfactorily origin, then you don't have a claim. And it's been an interesting, I'm sure this will be a topic throughout the workshop, sort of interesting that sort of diplomatically, I believe the PRC's position is still that it did not originate in its territory. But on the other hand, its behavior suggests that it does realize there is value in the pathogen and in subsequent research on the pathogen, including the delay between when the DSI was released and when the sort of biological samples became available. And so I'm comfortable with the conclusion I reached, because I think that if you can't prove origin or traceability, then there's no benefit to be shared. And hopefully that will be enough of an incentive for the research community to proceed and not fear later claims. But it's a point. Again, it's sort of Ran Charles and Michelle have done some really important work, sort of getting really into the details of that.
Thanks, Sam. If Charles and Michelle aren't going to continue to talk about country of origin, I might just throw to Margaret, who had a question about the copyright. Or did either of you want to continue this particular discussion? No. Okay. So Margaret, do you want to ask your question on air?
Sure. So can you hear me?
Yes.
Okay. I'm just, it seems to me like DSI is not just copyright, but it's like a hybrid between copyright and patents. And I wonder, we've had this same discussion around sui generis mechanisms for Indigenous knowledge, and the chance of getting a new category up off the ground is pretty slim. It feels like it's something that's not quite copyright. And I just wonder if you've thought about that.
Oh yeah, absolutely. It's so I think the best way to describe at least the articulation in the chapter is it's an analogy, and it is, I think, a useful analogy. I actually sort of, at least the way that I encounter DSI in the literature, it actually isn't patentable, right? There isn't an inventive step in the kinds of resources I'm analyzing, at least in the chapter. Now, it is true, right? Sort of like all of you are probably familiar with the Myriad decision from the US Supreme Court, where that inventive step can be pretty incremental. But at least for purposes of the paper, I try to literally just the sequence itself, and not a kind of adaptation or innovation in the underlying resource. But I agree with you 100%. It's my best effort, but you were exactly right. It is, for a lot of reasons, it is not perfectly analogous to copyright, for sure.
Thanks, Margaret and Sam. Michelle.
Thank you, Sam. I am really excited about this country of origin stuff. I think we could talk about it all day. But my question is about digital sequence information, and there's been suggestions as that discussion has evolved, suggestions about separating access from the benefit sharing. And I think even some of the people on the workshop have made this suggestion themselves. A lot of the WHO documentation doesn't seem to ever consider anything like that, it's always like a bilateral transaction access for benefit sharing, quite direct. I was wondering, do you think a pandemic treaty would consider this sort of DSI model where everyone contributes both pathogen samples and benefits that get spread out in a multilateral way? Or are they still stuck on this bilateral thing?
No, for sure. So in the chapter I put, and I can't know how many people have probably like seen the workshop. So it's not even a report. It is sort of the analysis or summary of a workshop convened by the CBD on DSI issues. And they do sort of walk through these sort of 4 scenarios. And one of them is a kind of sort of uniform rule for access. Everybody sort of contributes pathogens as they are identified as pathogens with human epidemic or pandemic or even infective potential. And then we just sort of figure out the benefits later, or there is no benefit, right? We agree that sort of the benefit is, sort of the protection of humanity. So that is very much part of the debate, but as you and Mark know, it has not made its way into the biohub literature yet. And there are these, and by the way, anybody's seen the SMTAs circulating, I'd love to sort of, and can't share them, I'd love to hear anything about them. I know that they are circulating. I haven't seen them, and I'm very curious sort of if it's addressed at all. But for sure, I think that there is an openness in the channels of communication between CBD Secretariat and WHO as to something other than these sort of bilateral approaches, I think.
That's great. I haven't seen the SMTAs either. That'll be very interesting.
I have those, but I can't share them. There's nothing in there about this stuff. They're very basic, and they're still tweaking them. They're having lots of pushback from the pilot program, from countries not wanting to sign them.
Interesting.
Yeah, fascinating.
It's
You've invited
much,
Mukul. This is great.
Yeah.
The workshop was it's like that one moment. No,
it's very much like
more than that, but it's
event,
actually very exciting to hear. Even
Great insights. Charles, you had a question.
Just a quick question. I wonder, Sam, if there's an important temporal question here, in that time is the essence when we're talking about pandemics. And so we need the discussion about ABS to happen, not in the context of I'm not going to give you samples until the ABS is sorted out, to giving the access and then sorting out the ABS. So we need some kind of legal mechanisms, and then they're going to involve trust and all those sorts of things to make sure that the process of getting there's a timely process which allows the pandemic virus or whatever it is to be exchanged and dealt with. So I wonder if there's also a need for some kind of institutional measures in your thinking for the future pandemic treaty about making sure that time is of the essence. And COVID's a great example. We got a vaccine in record time, amazing time. But if that had been delayed 12 months or so, which would have been quite easy if we'd had to dispute about, an Indonesia in 2007 is the classic example. You can't have it until you sort out and deliver on the benefits. I wonder if that's actually an important part of the pandemic treaty. And it hasn't really been part of the discussions of the national emergencies and those kinds of things either. But I wonder if that's something that we need some kind of institutional mechanisms in place to address.
Yeah, I mean, for sure. So the UK has been pretty explicit about sort of not only the establishment of regional kind of hubs for zoonotic research and sort of pathogen information sharing, but that kind of commitment be explicit in an international pandemic agreement. Yeah. So I think that I don't think you'll have trouble getting to agreement on time being of the essence. I mean, there may be some holdouts. I think you'll really get to what will hold it up is the benefit sharing piece in the multilateral negotiation. At least.
Yeah, but I wonder if that's actually going to be a key element of the pandemic treaty, is making sure that time does remain of the essence.
Yeah, I mean, in this, how about I answer it this way? In the public statements by Tedros, in the public statements by sort of the UK Foreign Ministry, that seems to be very clear. As the negotiations unfold, I don't, who knows what will happen. But it's certainly very clear as a threshold matter and a priority, I think.
Fantastic. Thank you.